Good morning. This meeting will come to order. This is a public meeting of the U.S. Commodity Futures Trading Commission. I'd like to welcome members of the public and market participants, as well as those on the phone or watching our webcast. I'd also like to welcome my fellow commissioners, Commissioner Quintens, Commissioner Benham, Commissioner Stump, and Commissioner Berkowitz. As always, we'll begin with the Pledge of Allegiance. Today, General Counsel Dan Davis will lead us in the pledge. And I want to let everybody know that last week, Dan received the Chairman's Award for Excellence. That is the highest award the agency bestows on a member of our staff. So Dan, why don't you please come up and Our General Counsel does not appear to be here. Is there anyone from the General Counsel's office that can ably represent our General Counsel? There we go. Herminio, thank you very much. To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Well, there's an old saying in leadership that you're as good as your people are. And so one of the reasons the General Counsel's office has done such a fabulous job is because it's staffed so well. On today's agenda, on the open meeting, we've got 3 items. First, we'll vote to finalize Part 13 of the Commission's regulations. And that will ensure that our rulemaking process is fully consistent with the Administrative Procedure Act. Second, the Commission will vote on whether to reopen the comment period and request additional comments on proposed regulations and amendments relating to capital requirements for swap dealers. Proposed regulations were previously proposed in 2011 and then reproposed in 2016. And then third, we will vote on proposed amendments to the swap clearing requirement exemption for inter-affiliate swaps. This proposal would revise the Commission regulation that exempts certain affiliated entities within a corporate group from the swap clearing requirement under our Section 2H1 of the Commodity Exchange Act. So now we'll start with opening statements. I'll go first, followed by my fellow commissioners in order of seniority. And I've been told some of them will actually split up their statements during the course of the rulemaking as we discuss particular items. For me, I'm actually going to combine my opening and closing statement into a single statement. And my statement is entitled, Tripling Down on Transparency. As regulators, we must be mindful not only of what we do, but how we do it. Our shared vision of the CFTC is to be the global standard for sound derivatives regulation. Soundness is built on transparency. Public input and dialogue help us serve our markets. We owe it to those who rely on our derivatives markets to regulate in the open. I've long thought that the CFTC is the most important regulator most Americans have never heard of. We're working to change that. By the end of next week, we will have held, this commission, all 5 of us, 6 open meetings in the last few months of 2019. That's the same number of open meetings the commission held during 2015, 2016, 2017, and 2018 combined. With the help of my fellow commissioners, and it is a lot of work, as well as the staff, I intend to continue this trend of open meetings in 2020. While transparency is important for all regulators, it's especially critical for us. The Dodd-Frank Act gave us jurisdiction over the $400 trillion notional swaps market. That's a humbling level of responsibility, and it demands we give the public visibility into what we're doing. We simply won't regulate from behind a curtain. Reaffirming the value of transparency is therefore vital. In 2010, this agency faced immense pressures in the wake of the Dodd-Frank Act, and the need to, quote, get things done didn't always lead to getting them done in the right way. Some have criticized the CFTC for stumbling in its commitment to transparency earlier in this decade. The agency from time to time used staff no action letters, policy statements, and enforcement actions rather than notice and comment rulemakings. While our predecessors on the Commission surely didn't make opacity the goal, it was sometimes the result. As we approach 2020 and beyond, I'm pleased to announce the CFTC will triple down on transparency by focusing on 3 areas. Number 1, how we make regulations. Number 2, how we apply them. And number 3, how we enforce them. The first area is transparency in rulemaking. We'll reaffirm the importance of notice and comment rulemaking under the APA. Today, as I mentioned, the Commission's voting on amendments to Part 13 of our regulations. The amendments will clarify how we receive, process, and respond to petitions for rulemaking. Part 13 also retains Section 13.2, which permits any person from the public to petition the Commission for a rulemaking. Now, that's actually a unique feature of the CFTC framework that reinforces transparency and the public's ability to participate. More importantly, we'll publish those petitions from the public for rulemakings on our website. That will further encourage public engagement with our rulemaking process. Because of the help of my fellow commissioners and our staff, we're also going to be publishing a summary of our rulemaking process on our website, written in plain English so everybody understands it. The second area is transparency in staff and other types of relief. In other words, how we apply our rules. Wherever possible, we should regulate with public notice and comment rulemakings. Staff relief should be a supplement, not a substitute for APA rulemakings. Today, I'm pleased to announce that the CFTC is finalizing guidance to ensure staff no action, interpretive, and exemptive relief letters are limited to appropriate situations. Examples will include unique circumstances that don't give rise or are not suitable for a general rulemaking, or only where temporary relief is contemplated. We must also increase transparency even where staff relief is appropriate. Today, I'm also announcing that as of January 1, 2020, the CFTC will publish all requests for staff relief on our website when our staff grants that relief. This harmonizes our approach with that of the other federal financial regulators, and it also provides greater public visibility into the issues before us. The third and final area of transparency is in enforcement actions. We've got to be transparent in how we enforce the law. A key goal of enforcement is to deter misconduct before it happens. Deterrence requires clarity about how our laws work. Long gone are the days when kings posted edicts high on columns to make the law harder to read and easier to violate. Our founders instead adopted a system in which the law is king. And it's been said that in our American system, the rule of law is the law of rules. As a result, our enforcement division will soon be providing an updated enforcement manual. This will inform the public of a number of changes designed to increase transparency. In addition, the Commission and its staff must be able to speak publicly about enforcement matters. Beginning on January 1, 2020, I will not present this Commission with any proposed settlement that restricts the Commission or our staff from publicly stating their views. Affirming this right to speak ensures the CFTC can inform the public about our enforcement priorities. It also advances customer protection. The facts of past cases can serve as early warning signs of new types of fraudulent and manipulative activity. But genuine transparency in the enforcement area can't be one-sided. Just as the Commission should be able to speak freely about enforcement actions, so too should defendants. Also beginning on January 1, I won't put before the Commission any settlement agreement that unduly restricts a defendant's ability to speak publicly. While we'll still expect defendants not to deny facts or statements that both they and the CFTC have agreed on, we won't stand in the way of comments or criticism. This approach is good for both transparency and accountability. Defendants can speak freely, but they also can't avoid tough questions by hiding behind settlement language. Transparency is sometimes avoided, particularly here in Washington, because it opens the door to criticism. But as Aristotle reminds us, criticism is something we can avoid easily by saying nothing, doing nothing, and being nothing. Well, that's never been the path of the CFTC during our nearly 45 years of regulating the U.S. derivatives markets, nor will it ever be. Just as we won't shrink from calling out wrongdoing, so too will the public have insight into what we're doing. Criticism isn't always pleasant, but it's a core facet of democracy. This commission is an agency of the United States government. The CFTC should be scrutinized when we act. In 1787, Benjamin Franklin was leaving Independence Hall in Philadelphia at the close of the Constitutional Convention. As the story goes, a woman came up to him and asked, "Dr. Franklin, what kind of government will we have?" He answered, "A republic, if you can keep it." Rest assured, our commission will do its part. Thank you very much. Commissioner Quintens, the floor is yours.
Thank you, Mr. Chairman. First, let me just take a minute to applaud your statement and your eloquence and comprehensive commitment to transparency through not only the open meeting process that we have, but important reforms to the Commission to ensure that what we do is transparent to the public. There is another saying that sunshine is the best disinfectant. It is hard to have accountability without transparency. And I, for one, am a strong believer in accountability for all of us to ensure that the public and our overseers on Capitol Hill know exactly what we're doing and how we're doing it. So, bravo. I'm going to save my comprehensive statements on these rules for their discrete consideration during the open meeting. But let me just cut to the chase and say that I'm going to support all three of them. And I really appreciate the staff's work from all the divisions and the Chief Economist's office and all the conversations that you've had with my staff to help us understand and also interpret and accept some of our points of view. So thank you again.
Thank you very much, Commissioner Quintens. Commissioner Benham.
Good morning. Thank you, Mr. Chairman, for having the meeting. Thank you for your statement. Like Commissioner Quintens, I will reserve statements as we consider each of the rules. Quick thanks to all the staff for all of their work and working with both myself and my office to get to today. So I look forward to the meeting, and thanks again for holding it.
Thank you very much. Commissioner Stump.
I'm going to reserve my comments for a bit later, but I did want to applaud you. I wholeheartedly support us having a more transparent and open process going forward with regard to the many things we do. I think it's particularly incumbent upon this commission, given that we, unlike 10 years ago, have the benefit of experience based upon the lessons we've learned as a result of the rules that were put in place post-crisis. And so it's very important for us to have that ongoing dialogue with the public to ensure that we have the right rules and the right modifications and the right calibration as we move forward. And I also would like to say we should never shy away from criticism. Some of the best policies I've ever worked on came as the result of having somewhat critical conversations with people who even sit on this dais today, and I appreciate that their opinions made the work product all that much better at the end. Thank you.
Thank you very much. Commissioner Berkovitz.
Thank you. Thank you, Mr. Chairman. I, too, fully support all your measures for transparency. You've been transparent in your support for transparency all along, and I'm a big proponent of that, and I think I applaud your leadership in that effort. I'm going to talk about some specific things, though, that you mentioned, and I feel compelled when we're talking about transparency. I feel compelled to respond to some of the statements that have previously been made, such as we're going to be transparent, unlike what they did previously, unlike what the Commission did in 2010, and they did it wrong back then, and we're going to get it right now. And I feel compelled to do this for the CFTC staff that's here, as well as my own involvement. In the Dodd-Frank years from 2010 to 2013, this agency did, depends on how you count it, approximately 65 rulemakings. I haven't looked at the website recently, but I believe we had between 45 and 50 open commission meetings on those rulemakings. And it was all the commission rulemakings. We published notices of proposed rulemakings, and we had final rulemakings, and people were complaining about all the meetings we were having. We were having too many meetings. We were going too fast. There was too much being made public. I also want to say that it's a record that I'm particularly proud of, and I feel somewhat uncomfortable sitting up here today saying this, but if I don't say it, it's not going to be said, and I can't leave the record as it is. Not a single rule, not a single of those 65 rules was overturned or successfully challenged on procedural grounds. There wasn't a single violation of the Administrative Procedure Act in any of those rulemakings. The only rule that the court invalidated was the rule on position limits, and it was a substantive interpretation of the statute where there was a mandate to issue position limits. We were up against the Office of General Counsel, and I see our Deputy for Litigation, who was part of that team. We were up against the best lawyers that private industry threw at us to overturn our rules on cost-benefit analysis. The Securities Exchange Commission lost 6 times in the U.S. Court of Appeals on cost-benefit analysis. Frankly, when we came in 2010, the cost-benefit analysis that the agency was doing were substandard, and we were challenged on it. The Inspector General issued reports saying we needed to up our game. Well, we upped our game on cost-benefit analysis. Office of General Counsel, the Office of Chief Economist, and the CFTC staff all worked together to make those cost-benefit analyses robust and survive challenge in the Court of Appeals. And we have a very strong opinion from the U.S. Court of Appeals affirming the way this agency did cost-benefit analyses. And we were up against the same lawyers that defeated the SEC 6 times on cost-benefit analysis. Okay, we did it right. We didn't cut corners. We were transparent. We were upheld in the U.S. Court of Appeals. SIFMA challenged us on what we did. ISDA challenged us on what we did. They challenged our cross-border interpretation, and they were unsuccessful. They said, oh, you can't issue guidance. You got to go a final rule. The U.S. courts, the federal courts agreed with us. I think we have a lot to be proud of in those years. Now, we got those rules done in 3.5 years without a single successful procedural challenge. And I think this agency has a lot to be proud of for that record. And those rules have held up over the years. Okay, and one reason those rules have held up over the years is because of the no-action relief that was granted. Admittedly, there was about 100 no-action letters granted in each of 2012 to 2013. That's a lot. But fundamentally, what those enabled us to do was get those regulations in place with a safety valve so that people could operate under those regulations successfully. Okay, we weren't rigid. If people needed more time, they got more time. If you needed to adjust this condition, we adjusted that condition. And the very fact that today and in the next meetings and previous meetings, we're essentially going to be codifying that relief because we now have the experience. The relief worked. We were able to put that in place temporarily, see how it worked, say, okay, well, maybe the rule needs to be adjusted here or there, and it worked. And now today we have the confidence that we can make that permanent. Rather than saying, okay, we're going to make this permanent, we're never going to change it, this is it, you know, we're going to make it really hard to adjust, to fine-tune the dial. Okay, we made it possible to fine-tune that dial, and then have the confidence, where the entire commission can sit and have the confidence that that's the appropriate way of doing business, and then we modify the regulations and make it permanent. So I think the no-action letters, while I agree that if you can put it in regulation, I think the no-action letters do serve a valuable purpose, and we need that relief valve. I wholeheartedly support the approach. I do think it's a big improvement that we're going to put the no-action letters, the requests on, make those public when we make the relief. I do think that would be a big improvement. Finally, on enforcement actions, I know the defense bar has been complaining all the time about making policy through enforcement actions. I wasn't here for a lot of the times they were complaining, but I've been on the outside, and I think that's a defense bar objection. I don't think that's really what the agency's doing. We have a statute to implement. Things like manipulation and fraud. As the courts have said, the methods of manipulation are limited only by the ingenuity of man. And as more ingenious methods of manipulation are presented to the commission, the enforcement staff in this commission has addressed those, and that requires an evolution of the law. And sometimes you apply new interpretations and new factual situations. I know the defense bar complains that that's making law as you go, but that's what you do in enforcement cases. You have to be able to have the flexibility to address. So I applaud the transparency. I fully support where you're going on that, and you have been a strong proponent of transparency, but I just feel I have to correct the record as to what happened previously in this agency's performance in the Dodd-Frank years. We were transparent, we were effective, and your statement, Mr. Chairman, about the best little-known agency, it's because of that. That's why we have the reputation. And my colleagues here who were on the Hill at that time, the other thing, we were looked, and this agency was looked, and it still is, looked as a resource for Congress and an objective resource. And part of the reputation is from those years, and part of it has been carried on by predecessors and successors. So it's a long tradition at this agency. Finally, along the lines of transparency, I want to really strongly support your statement that you're not going to put before the commission any settlement agreement that constrains the commission, individual commissioners, or commission staff from making public statements about that matter. You've been steadfast in your views on that matter, and I've appreciated it all along, and I appreciate it here today. I am, however, disappointed. Those of you who have been watching the agenda will notice that we actually had a proposed rule was on the agenda, but it's not on the agenda that would essentially codify that practice. I'm disappointed that we're not ready to go to a proposed rule on that today. Ensuring the transparency and accountability of the Commission's operations and enforcement actions should be a high priority for this Commission. It certainly is a priority for me. During my tenure as a Commissioner, I will never agree to any gag clause with any party settling an enforcement matter with the Commission. I will continue to exercise my right to speak on all matters before the Commission, a right that was recently affirmed by the United States Court of Appeals and is written in Section 2A10C of the Commodity Exchange Act. Neither a majority of the Commission nor any consent order can take away that right. Under no circumstance will I agree to be silenced or agree to let the Commission be silenced or the staff by any person that the Commission believes has violated the Commodity Exchange Act. Thank you, Mr. Chairman, and I look forward to discussing today's rules.
Thank you very much. For each of the items on today's agenda, the staff will make presentations to the Commission. After each staff presentation, the floor will be open for questions and comments from each commissioner. Following the close of discussion on each matter, the Commission will vote on the recommendation. All final votes conducted in this public meeting will be recorded votes. The results of the votes approving the issuance of rulemaking documents will be included with those documents in the Federal Register. To facilitate the preparation of approved documents for publication in the Federal Register, I'd now ask the Commission to grant unanimous consent for staff to make necessary technical corrections prior to submitting them to the Federal Register. Without objection, so ordered. At this time, I'd like to welcome the following staff for their presentations on the final rules amending Part 13. From the Office of General Counsel, we have our General Counsel, Dan Davis, and Senior Special Counsel, Herminio Castro. The floor is yours. Thank you.
Thank you, Mr. Chairman. Thank you, Commissioners, for the opportunity to present on Part 13. I appreciate all of the input that we've gotten from your respective offices, which I think has made an excellent final rule here. Without further ado, I'll turn it over to Erminio Castro, and I wanted to thank Erminio and Deval Patel who put in the effort from OGC on this rule.
Good morning. My name is Erminio Castro, Senior Special Counsel with the Office of the General Counsel. Today, staff recommends that the Commission adopt the final rule to amend Part 13 of the Commission's regulations. The staff also recommends that the Commission adopt a summary of the rulemaking process for placement on the Commission's website. Part 13 of the Commission's regulations was originally promulgated in 1976 and has not been updated since that time. It sets forth the rulemaking procedures for the formulation, amendment, or repeal of rules that directly affect the public. The final rule would eliminate the provisions in Part 13 that set forth the process for issuing rulemakings. As originally adopted, Part 13 was intended to track the rulemaking process set forth in the Administrative Procedure Act, or APA. Because the APA governs the rulemaking process, it is unnecessary to maintain this process in a Commission regulation. Also, in its current form, Part 13 does not fully conform to the APA, which may create ambiguity and confusion about the procedures to be followed by the Commission in rulemakings. Accordingly, the final rule eliminates the provisions that set forth the process for promulgating rulemakings. Part 13, as amended, would, however, retain Regulation 13.2, renumbered as 13.1. which describes the process for filing a petition for rulemaking, which the APA does not specifically address. The proposal was published on September 20th, 2019, and the comment period closed on October 21st, 2019. We received 2 comments on the proposal from Better Markets, Inc. and the Administrative Conference of the United States, or ACUS. The ACUS asked the Commission to consider conforming the final rule to ACUS recommendation on petitions for rulemaking issued in 2014. Better Markets recommended the Commission implement ACUS recommendation concerning ex parte communications, also issued in 2014. In light of the comments received, we modified the proposal to allow the electronic submission of petitions for rulemaking, and it will be the Commission's policy going forward to post the petitions on the Commission's website. We also note in the preamble that the Commission will decide on a case-by-case basis whether to solicit public comment on petitions for rulemaking. With regards to ex parte communications, while the APA does not prohibit ex parte communications, we noted in the preamble that it is the Commission's policy to make public on the Commission's website substantive ex parte communications, both written and oral, that provide significant material information addressed to the merits of a proposed rule. It is also the Commission's practice to make public on its website all ex parte meetings held on proposed rules, including the names and affiliations of attendees. Finally, the summary of the Commission's rulemaking process explains in plain English the Commission's process for promulgating rulemaking by the Commission. It also explains the Commission's policy and practice on ex parte communications. I would like to thank Deval Patel, counsel with OGC, for her assistance drafting this rule. I'm now happy to take questions.
Thank you very much for that informative presentation. To begin the Commission's discussion and consideration of these rulemakings, I'll now entertain a motion to adopt the final rules amending Part 13.
So moved.
Second.
Thank you. I'd now like to open the floor for commissioners to ask any questions or make comments. Since I've already explained why I'm supporting this rule, I'll turn to Commissioner Quintens.
Thank you, Mr. Chairman. I don't have any questions. I'd just like to compliment you on your work. It wasn't that long ago that you were here with the proposal in front of us, and I know that it takes a significant amount of effort to turn something around that quickly. So thank you, Armino and Dan, for your work on this. I think it's an important rule for us to finish. Thank you.
Thank you, Commissioner Benham.
Just echo Commissioner Quintens' statements. Erminio, thank you for your work, and Deval as well. I know is not here. Mr. General Counsel, thanks for your support. I do want to especially thank the chairman and the staff for working with my office to put the web page up, which I think, in the spirit of transparency, is going to be a really nice step for the public to understand. In the absence of this more prescriptive language, which I know is outdated, the webpage will be a sort of user-friendly tool for the public to understand the rulemaking process within this agency. So thank you again for your work, and look forward to seeing the website.
Thank you, Commissioner Stowe.
I have no questions. Thank you all.
Commissioner Berkovitz.
Thank you, Mr. Chairman. Thank you, Herminio and Deval. Appreciate your working with my office on this rule and working to address the comments. And I just want to discuss one of the comments we received from Better Markets regarding ex parte communications. And although that's not part of the rule, my understanding and my reading of the preamble is we are reaffirming our practice and policy in that respect. And could you just briefly summarize that policy and practice on ex parte communications that we're reaffirming?
Yes, again, the Commission's policy is to include all ex parte communications involving oral or written communications that go into, that are significant, provide significant material information. And it is the Commission's policy then to place that on the record. Also, it is the practice of the Commission to post ex parte communications meetings on proposed rules. And so we regularly place those also on the Commission's website.
So if there's a meeting or any other type of communication where new information is provided, that new information would be put on the comment part of the website?
Yeah, as long as that information pertains to proposed rulemaking and provides significant material information.
Thank you. And this will be explained as part of that posting on the website about our rulemaking process?
Correct. We added that particular, regarding the policy and the practice, we added that to the rulemaking explanation.
Okay, again, I thank you very much, and I think this is part of the transparency that the chairman has been referring to and supporting, so I appreciate your responsiveness and your clarity in which we're making public these policies and practices. Thank you again very much.
Thank you, Commissioner Berkovitz. Well, if there are no other questions or comments, are my fellow commissioners prepared to vote? Okay, it appears so. So, Mr. Kirkpatrick, will you please call the roll?
Thank you, Mr. Chairman. The motion now before the Commission is on the adoption of the final rule amending Part 13 of the Commission's regulations. Commissioner Berkovitz. Commissioner Berkovitz votes aye. Commissioner Stump.
Aye.
Commissioner Stump votes aye. Commissioner Benham.
Aye.
Commissioner Benham votes aye. Commissioner Quintens.
Aye.
Commissioner Quintens votes aye. Chairman Tarbert.
Aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 5, the noes have 0.
Thank you very much, Mr. Secretary. The ayes have it, and the motion to adopt the final rule is hereby approved. Okay, at this time, thank you very much. At this time, I'd like to invite a second presentation on a proposal that would reopen the comment period and request additional comment on the Commission's proposed capital requirements for swap dealers and major swap participants. Specifically, we have from DSIO, Director Josh Sterling, Deputy Director Tom Smith, Associate Director Josh Beal, Special Counsel Jennifer Bauer, and Senior Financial Risk Analyst Rafael Martinez. From the Office of General Counsel, we have Associate General Counsel Paul Schlichting. I will go ahead and give the floor open to you, Josh. Thank you.
Good morning, Mr. Chairman and Commissioners. Good morning to you as well. Again, it's a pleasure to be before you with representatives of my world-class staff to talk to you about a very important step in our regulation of swap dealers. We're putting before you and recommending that you vote for reopening the comment period on our 2016 capital proposal. Just a few quick highlights on that. Capital is the last substantive rule we would adopt with respect to swap dealers before our swap dealer rule set is complete, the effect of which is that swap dealers would transition from being considered provisionally registered with us and provisional members of the National Futures Association to having a full registration. So in some respects, this will be, when it is finally brought forward to a final rule, a capstone event in our regulation of swap dealers under Dodd-Frank. And I think the Commission as a whole can take great pride in moving forward in that regard. I would say that we are reopening the comment period because we think it's appropriate to take notice of events that have transpired since the 2016 proposal went out for consideration by the public. First of all, we received a number of important public comments that gave us an opportunity to think about our approach. We also said at the time that we anticipated the SEC would move forward and ultimately adopt their capital rules for security-based swap dealers, and indeed they have. We think that inasmuch as Section 4SE of the Commodity Exchange Act requires essentially collaboration amongst financial regulators in getting to final rules, that we should take fair notice of what the SEC has done and consider those developments in light of what's appropriate for our registrants and our markets. The last thing I would say, by way of a highlight, is that we are affording a 75-day opportunity to comment on the release. Now, we've asked for comments in 16, 17 or so specific areas. The entire 2016 proposal is, of course, open for comment by interested members of the public. We look forward to having their comments, so we feel like a 75-day period to effectively comment again on the 2016 proposal is a very measured and thoughtful way for us to get good feedback to come to you soon thereafter with a recommendation on what a final rule set for capital would look like. Now, before I hand it over to the team, I just want to thank them all for their hard work. We, of course, have Tom Smith, Josh Beal, Jennifer Bauer, and Rafael Martinez before us today. I'd also like to thank the General Counsel's Office, Dan Davis, Paul Schlichting, and Carlene Kim in particular. And, of course, the Chief Economist's Office was quite helpful as well. Bruce Tuckman worked closely with us, as did Hong McPhail. And I think in particular, Matt Dagler in your office, Mr. Chairman, should be thanked for his involvement and input as well. It was indeed vital. So with that, I will turn it over to Tom. Or Josh.
Thank you, Josh. Mr. Chairman, Commissioners, staff requests Commission approval to publish in the Federal Register a notice to reopen the comment period of the 2016 swap dealer capital proposal for 75 days. Consistent with the statutory requirements in the Dodd-Frank Act, Division staff provided each of the prudential regulators and the SEC an opportunity to review and comment on the proposed notice to reopen the comment period. The 2016 proposal would implement provisions of Section 731 of the Dodd-Frank Act that direct the Commission to adopt regulations imposing capital requirements and financial condition reporting on swap dealers and major swap participants. The Dodd-Frank Act applies a bifurcated approach that requires each swap dealer and major swap participant, for which there is a prudential regulator, to meet the capital requirements established by the applicable prudential regulator. Each swap dealer and major swap participant for which there is no prudential regulator, including non-bank subsidiaries of bank holding companies, to meet the capital requirements adopted by the Commission. To date, there are 107 provisionally registered swap dealers with the Commission. Of those 107, 54 are subject to the capital and margin rules of the Commission, while the remaining 53 are subject to the rules of a prudential regulator. The 54 provisionally registered swap dealers for which the Commission is primarily responsible for establishing their capital requirements represent a diverse set of swap dealer registrants. Based on our analysis, 4 of these firms are large alternative net capital broker-dealers already duly registered with the SEC. 22 represent foreign domiciled entities, likely subject to existing comparable capital requirements of a foreign regulator, while several of the remaining are non-bank subsidiaries of existing bank holding companies or standalone commercial entities or subsidiaries thereof. For these reasons, the 2016 proposal was flexible in its design and permitted compliance with the Commission's minimum capital requirements by leveraging off of already existing capital regimes. That proposal offered swap dealer registrants a choice of one of three methods to calculate their capital under the Commission rules. The first, a Basel-based method, which incorporated by reference certain capital adequacy rules of the Federal Reserve Board, as if that swap dealer itself was a bank holding company. The second, a net liquid assets method, which incorporated by reference the SEC's proposed and now finalized rules applicable to security-based swap dealers and is based off the capital requirements traditionally imposed on futures commission merchants and broker-dealers. And third, a tangible net worth method designed for swap dealers or major swap participants that are predominantly engaged in non-financial activities. The 2016 proposal also included a capital comparability determination process, wherein foreign domiciled swap dealers could apply to the Commission to utilize a capital regime of a foreign regulator subject to certain conditions. For those swap dealers duly registered as futures commission merchants, the 2016 proposal required these registrants to comply with existing FCM net capital rules, and several amendments to those rules were proposed to better reflect swap activities. Finally, the 2016 proposal also included reporting, record-keeping, and notification requirements. These requirements are comparable to already existing reporting, record-keeping, and notification requirements for futures commission merchants, and to the extent practicable with the SEC's requirements for security-based swap dealers. I'm now going to turn the presentation over to Jennifer Bauer to discuss the specific components of the 2016 proposal, which have been incorporated into the reopening document before you today.
Thank you, Josh. Following the 2016 proposal, Commission staff analyzed the substantive comments and met with commenters. Staff also met several times with SEC staff in the finalization of their capital rules, as well as consulted the prudential regulators for comment. The matters this notice specifically highlights for further comment are a result of these efforts, as well as consideration of the SEC's final capital rules for security-based swap dealers. This notice of reopening addresses the 8% minimum capital floor calibration. Commenters noted concerns with the 8% risk margin calculation, with several suggesting the Commission consider lowering the percentage. One commenter suggested that the 8% calculation was appropriate and necessary in light of permitting the use of models to calculate market and credit risk capital charges. Some commenters also suggested that the calculation should only be applied to a lesser subset of the derivatives positions of the swap dealer. This notice for reopening contains several questions to obtain additional information for the Commission to consider with respect to this aspect of the risk margin calculation, including how the 2016 proposal calculation would be quantified under swap dealers electing each approach. Specifically, the notice requests commenters, wherever possible, to also provide data for the Commission's consideration. This notice of reopening addresses how the 2016 proposal impacts FCMs, including in adopting standardized market charges for swaps. Commenters raised concerns with the 2016 proposal's impact on FCMs, specific to the addition of proprietary cleared swaps to the FCM net capital floor, given that proprietary cleared swaps positions are subject to existing FCM net capital charges. The notice requests further comment on not adopting the proposed additions to the risk margin floor for standalone FCMs. Also, the notice requests further comment on the proposal's addition of FCM standardized market risk charges for swaps, which are incorporated by reference in the standardized swap dealer market risk charges. This notice asks for comment on technical changes to the 2016 proposal grid for credit default swap market risk charges and on a change to the standardized market risk charge for uncleared interest rate swaps from 0.5% to 1/8% in order to maintain alignment to the standardized charges with the SEC. Further, the notice requests comments regarding the inclusion of some types of offsetting for the standardized market charges applicable to commodity and currency or other swaps, where there is existing offsetting permitted in the application of net capital charges on the underlying instruments, also as aligned with the SEC. This notice of reopening addresses the composition of capital. Based on suggestions of commenters, this notice asks additional questions regarding potentially modifying the bank-based approach, including the advisability of adding more layers than only common equity Tier 1 capital to the calculation. For example, to permit the consideration of qualifying subordinated debt to count as capital. This notice also addresses the suggestion of other commenters that asked whether the tangible net worth approach should be adjusted to consider swap dealers organized under a parent organization that is predominantly engaged in non-financial activities. Accordingly, this notice asks additional questions concerning the qualifications necessary for the use of the tangible net worth approach. This notice of reopening addresses model approval. Many commenters, anticipating a model approval backlog, raised issues concerning the logistics of model approval in the 2016 proposal and emphasized the importance of being able to use models to compute market and credit risk net capital charges on swaps. The notice asks additional questions on possible revisions to the model approval process, including specifically highlighting and asking for additional comment on one commenter's suggestion for revised rule text. The notice of reopening addresses liquidity requirements. The 2016 proposal provides that swap dealers electing the bank-based capital approach also comply with a liquidity requirement based on high-quality liquid assets, as if the bank holding company liquidity coverage ratio were applicable specific to the swap dealer entity. A separate liquidity requirement was proposed for swap dealers using the net liquid assets capital approach based on monthly liquidity stress tests. When the SEC finalized its capital rules, it declined to finalize its proposed liquidity requirements. Commenters suggested with regards to the liquidity requirements that any swap dealer be able to elect either method of the liquidity requirement regardless of the chosen capital approach employed. So the notice contains further questions in light of those comments and in light of the SEC's deferral of adopting liquidity requirements. Finally, this notice of reopening addresses financial reporting for swap dealers. Several commenters asked that the Commission consider changes to specific aspects of the financial reporting and notification rules contained in the 2016 proposal. The notice, therefore, asks questions regarding those specific requests, including expanding the use of international financial reporting standards, extending the time period of routine financial reports, and the advisability of changes to certain public disclosure requirements. So the notice asks questions regarding these technical amendments to the financial statement rules to ensure harmonization in financial reporting. That concludes our presentation of this notice of reopening. Thank you, and we'd be happy to answer your questions.
Thank you very much for that presentation. Very informative. At this point, I'll entertain a motion to approve the division's proposal for the notice of reopening and request for comment related to the capital requirements for swap dealers.
So moved.
Second.
Thank you. I'd now like to open up the floor for commissioners to ask questions and make comments. I think this time, why don't we start with you, Commissioner Berkowitz.
Thank you, Mr. Chairman. I want to, first of all, this is a very complex rule, as evidenced by the highly qualified and numerous staff at the table. And I want to thank the staff, again, for their interactions with my office and responsiveness to a number of our comments in a very short period of time. You're very responsive in our discussions. So I want to say at the outset that I do appreciate that. I have some fundamental concerns with the proposal, nonetheless, that simply insufficient time that we had with this proposal to become comfortable with. And one of the things, Josh, I think you said is that do you intend this to be the basis for a final rule, this document?
Mr. Commissioner, thank you for your question. The short answer is yes. The slightly longer answer is this proposal and the comments from it will inform the 2016 proposal, so it's rather on a continuum.
Okay, so the 2016 proposal actually made a specific proposal in terms of rule text and what the various capital requirements should be and the alternative methods of calculation, correct?
Yes, sir, that's right.
And we've got a large number of comments negative towards those specific proposals in 2016.
We received a number of informative comments. I don't think that they all agreed with the approach we initially articulated.
And I think Jennifer, you stated that one of the things that is done here is, in this document, is suggest some alternative approaches, for example, the SEC's approach and other potential suggestions, and ask for comments on those other potential approaches or modifications.
Thanks, Raphael. The structure of the 2016 proposal has not changed, and we received what I would view as comments informing aspects of that. And what we are reopening is the same proposal with further information provided by commenters. To alert other commenters to the universe of comments, we have tried to summarize some of their thoughts here, and where appropriate, and we think that in a few places, rule text was suggested. We've put that in to alert the whole universe of commenters as to what those potentially could be.
Right.
I'll just add something, Commissioner. In the 2016 proposal, yes, there was specific rule text and language as to what the commission was looking for with a capital rule, but it also requested specific comment on such things as the 8% and the common equity tier 1 capital. Right. Questions were asked: was it too high? Was it too low? How should it be adjusted? Should there be changes to the products that are included in that? So those are the types of things that the commenters did provide feedback on during the comment process, which we are highlighting here now to say what would be beneficial to the commission in going final is if we can quantify some of these differences to come up with a appropriately calibrated approach to the capital.
Okay, so I think I appreciate that, and that's actually consistent with the example that I'm going to use here. And I'll just read from the proposal that we're going to be voting on. It's consistent, Tom, with what you just stated. The commission, this is one of, and it depends what you count as a question. I counted, when I went through the document, 140 questions. So there's a lot of questions and there's a lot of alternatives. You could may go one way on this and may go one way on that. And there's, if it were just binary, if it were just yes or no, with 140 questions, you could have what, 140th potential rules coming out of this document. A lot. There's a lot of ways to go on this. But let me read you on this 8% question. Here's some of the questions or statements. The Commission requests comment on whether the proposed 8% risk margin amount should be modified for SDs electing the bank-based capital approach, the net liquid assets capital approach, or the targeted net worth capital approach to a lower percentage requirement such as 4%. So we're asking about 4% in addition to about 8%. If so, is 4% risk margin properly calibrated to the inherent risk of the SD and activities that engage in it, that it engages in? If not, 4%, what percentage of the risk margin should the commission consider? Okay, and then it goes on. 1C, the commission requests comment on whether the proposed 8% risk margin amount should be modified to be harmonized with the approach adopted by the SEC for SBSDs and the SEC final capital rule. Specifically, should the commission modify the regulation to lower the risk margin amount percentage from 8% to 2%? So we're asking 8%, 4%, 2%, right?
Mm-hmm. Yes.
So there is no data in this rule. We are not proposing, we've asked, let me ask this question. We are asking if you think, the commenters, we're asking if you think it should be 4%, tell us why and give us data, correct?
Yes, sir.
If it should be 2%, tell us why and give us data.
Yes.
Okay, now, but we do not have the data right now, and we are not proposing data. We're asking for it, whether to go to 4% or 2%. Is that correct?
We're asking, that's correct, Mr. Commissioner, in the sense that we are asking members of the public to provide us with information sufficient for us to consider those possibilities and recommend a choice that would be good. In fairness, I believe that a lot of the information that would be required to be provided to articulate what they believe an acceptable standard would be, there are significant privacy interests in the retention of that information. And so we are trying to design a process where we can have conversations about that, receive information about that information from the public by giving them specific choices to look at within a range of 2 to 8%.
Sure, but we do not have the information currently now to propose a 4% or a 2%. That's the whole purpose of this. We want comment to be able to potentially, depending on what the data shows us, we'll look at it. Some people will say we like 8%, some people will say 4%, some people will say 2%, some people will say 0%, some people will say go with the prudential regulators at their numbers at 6.5% or whatever. Mm-hmm. So there's a whole range of possibilities, there's a whole range of data that might come in, and our job as the commission is to choose which one of those based on the data that we don't have. And then we would decide, you come to us with a recommendation, correct? Because if we had it, why aren't we making the decision, you coming to us now instead of asking them for it?
Right. Well, Mr. Commissioner, I take the point. I believe that, I mean, we could be here today coming to you with a final rule set for the commission to consider for action, wherein we would have made a choice that we thought was right, and then we could deal with it substantively going forward, but the decision would have been procedurally found. We thought the better approach would be to ask the public, well, what do you think, based on the information you got? And I think that going between 2 and 8% is an exercise that the SEC recently experienced. We think that asking within that range will get us a lot of valid input from the public, but you're fundamentally correct, sir. We do need to ask, so we are.
Okay, and I also want to make it clear that I support, and I've always supported, and I continue to support data-based rulemaking. I think it's good that we're asking for data. If the commenters don't like 8%, I think it's the proper approach to say, if you don't like 8%, tell us why you want 4%. Or if people say you should harmonize with the SEC, back it up with data and arguments, not just the argument harmonization for harmonization's sake, but is it substantively correct? So we need the data to adopt an alternative. We're not proposing an alternative. We're thinking about alternatives, and we want data to be able to justify a final rule, which we don't have yet. There's nothing out there that the public can comment on as to going to 4%. There's no notice and comment on 4% on a proposal for 4%. There's no data to justify it.
Well,
that we're putting out.
Sir, we are not putting forward 4%. We're suggesting and asking questions, as you've read into the record, sir, to ask what the right amount would be supported by data. I think that the 2016 proposal, if I have it right, and please correct me, team, if I'm wrong, put out a percentage for risk margin, and now we're asking whether we got that right. So I think when we get to a final rule recommendation for you, we will have a percentage that is backed up by data in our assessment of it. And I don't think that whatever number we were to decide, between a range of 2 and 8%, let's say, will leave the public somehow guessing or not knowing our thoughts or our intentions. I think we're being quite deliberate about that.
Oh, exactly. And Jennifer, did you have one to add?
I just want to clarify one thing, because you had spoken about the 6.5%. That's not a risk margin. That's a separate bank-based approach off of risk-weighted assets. That's not changing. The floor of risk margin percentage was something that we proposed in the 2016 proposal, applicable across the board, and we received a lot of comments about the floor, but we aren't proposing changing the concept. Really, the questions for additional comment are about calibrating the percentage. The SEC's final rule discussed the iterative process of getting this right is sort of, you need data and to implement, and over time you will focus in on the exact right percentage. And we asked questions about whether we should follow what the SEC did. They also proposed 8% and adopted a final rule, asked questions then in a reopening, and then adopted a final rule that has a 2% with a possibility of ratcheting up to 4 and 8 over time, similar to what you said about the no action process, trying to get things right, but also get to implementation. I think the questions we're asking about the 8% risk margin amount are an attempt to ask the public to give us this data as much as possible, but it may be in the final rulemaking that it's something that may take iterations for this commission to get right. I don't think anyone has any intention of doing anything other than getting as much information possible from the public about this amount. However, the approach is how to count capital, what qualifies as capital, the ability to use these depending on the type of swap dealer, being able to use these different flexible approaches that are consistent with the SEC, are consistent with the prudential regulators. All of that rule text is in the 2016 proposal and is not changing, and we're not proposing to change it. We're asking on these things that commenters have raised, we want to make it public to the other commenters. What are the things that are the main concerns? What are the things that could be tweaked? Give us more information about that, and where it was an actual change to rule text, we included that, but it's very minimal and consideration of the entire package of rule text from the 2016 proposal.
And I appreciate that, and let me just get to the heart of my concern. If we are asking commenters for reasons to support an alternative approach to what we proposed, and that approach that they suggest provides us with new important data to justify, that would justify a different approach from the original proposal, and we're relying on that information from the commenters to go a different way, that we can't just go to final, that information has to be put out, we have to repropose. That's the thrust of where I'm getting at with this, that we can't, that in a APA notice and comment rulemaking, the commenters have to have an opportunity to comment on critical data relied on by the agency, important data relied on by the agency. If we want to get different data to support a different rule, or the data, the commission concludes it wanted to go in a different direction, then that's fine. And we should go in a data-based way. We should be data-driven. But we can't ask the commenters, say, well, what rule do you like? Give us the data, and then pick the best rule and data from what the commenters provide us. We have to subject that different approach. If we're going to deviate from 8% and go to 4% or 2%, and we're asking for data to justify it, and we get that data and say, we believe we should go in this different direction, that has to be subject to public comment. That's the whole bunch of case law on that, and can talk to the lawyers about it, but that's I believe the law. So that's my point. If we're going to get this significant new data, it's a big data call in this thing. This does not support going to a final right away. We have to repropose.
Thank you, Mr. Commissioner. We understand the point and take due note of it. Thank you.
Good.
Okay.
Are you all right?
Well, I have
one more.
The other point that I would raise is more on the substance, and it's in my written statement, but I've used up a lot of time on the process. But I would emphasize what I've said before. Harmonization for harmonization's sake is not a sufficient reason to do something. Just because the SEC has gone to a certain level doesn't mean we should do it just because they've done it. It has to be independently supported. I'm also concerned that every place in this thing, in this reproposal, the tendency is encouraging sort of a backing off from where we were in 2018. So I have that overall concern, and I have the procedural concern. So thank you, Mr. Chairman.
Thank you, Commissioner Berkovitz. Commissioner Stump.
Thank you, Mr. Chairman, and thanks to the team and the Office of the General Counsel and the Office of the Chief Economist. You all have spent considerable time with us working on this, and I really appreciate it. Just based upon the number of questions my team had, I can only imagine how many meetings you had to have to help us better understand this very complex rule. Relative to reopening the comment period and asking additional questions, I'm extremely supportive. Building upon something Commissioner Berkovitz said, I do so with an open mind. I'm not pre-assuming what the outcome is going to be. I, in fact, had a question about, offering these different options, but preserving the ability to consider them as a non-exhaustive list of just that, options. The questions that are very specific with these specific numbers may, in fact, not be where we land. Whether or not that requires us to repropose or go to final is actually not the question we should be asking. The bottom line is it's time to get this right. If we have to repropose it, we have to repropose it. Any information, and I applaud you all for asking for data-driven information, is going to help us get this rule to the place it needs to be. But the reality is that the reason it's taken us so long to do this rule is because it is extremely complicated. And the market participants that this agency deals with in this context are quite diverse. Some of the other regulators didn't have that type of diversity when they attempted to finalize these rules. So it is complicated. It's taken us a while. It is time to finish it, but we have to finish it correctly. So I thank you all for all of your time and energy and the many hours you spent just with my team alone. So thank you. I'm very supportive of reopening the comment period, hearing from the public, and getting this right.
Thank you very much. Commissioner Benham.
Thank you, Mr. Chairman. Thank you to all the staff. Appreciate your time in doing all this hard work with your discussions with me in the past few weeks and my staff. A few questions I had are similar to Commissioner Berkovitz's, so I will try to work around them and avoid duplicative question and answer scenario. So I'll try to get a few things about the core of the rule itself, and then a little bit about some of the additional questions, which in my mind stray a little bit from the original 16 proposal. And then, Mr. Chairman, after I conclude, hopefully a quick Q&A session, I'll read my statement as well. Josh Beal, you mentioned the three methodologies, and I believe we talked about this, but I think it's good for the public to understand, and also for us to just maybe unpack a few more things. We have the Basel method, the FCM BD method, and the tangible net worth method. And something that, as I read the document, I thought about was, are we trying to get to the same place using three different methods? And I know clearly with the tangible net worth method, as you pointed out, it's specifically focused on commercial end users because of the type of businesses they run, the organizational setup, and the physical assets they have as compared to a traditional banking organization. But just as a broad matter, using these three different methods, depending on what the entity chooses, what methodology they choose, from a regulatory standpoint, are we trying to get to the same place on the back end, or do the three methods sort of serve different purposes that will allow us to assess risk individually in a more bespoke manner based on the organization?
My personal view is that each of the methods requires capital at the end of the day. How you get there is obviously very different. So in my mind, it's better to have something than nothing. But we acknowledged in the 2016 release that we needed diversity because of the large number of diverse registrants that we had. And we knew that several of them were already maybe subject to a capital rule or by the effect of their parent organizations. So each of the methodologies will likely result in different conclusions as to what their specific quantitative capital will be. But I think as a whole, all of that is intended on achieving the regulatory purpose behind capital, which is to have something there at the end of the day for wind down and operations and cover holistically entity level risk at the end at the organization.
Great, thanks. Jennifer, you discussed, I believe it was you briefly, about internal modeling. That was a question and a comment that has come up, and it's been an issue, I know, from a policy perspective for a number of years. And I think the commenters focused on the challenge of getting model approvals from the regulators. Can we talk a little bit about maybe what the process is in terms of model, when an entity chooses a specific type of model methodology, and then what the relationship is and what the conversations are with the regulator? And given the sort of vast pool of regulators that some of these organizations have to deal with, they have different methodologies for prudential regulators versus different market regulators, and how this sort of all comes together.
Sure, and I may include Raphael here, sure. But to start, the proposal, the 2016 proposal provides that the swap dealers can apply for approval to use models to calculate market risk and credit risk charges. And those would be VAR models. And we included a very substantial amount of qualitative and quantitative requirements for those models. So the models that they submit have to meet those qualitative and quantitative requirements. And then they would be verified to meeting those by the NFA, and then once that process is completed, they would be approved to use those models. So the concerns of commenters were that's going to be quite a process. It's going to take some time. In the meanwhile, if they had to use standardized charges, that may be a competitive disadvantage because those would be perceived to be a much higher and onerous capital charge. So that's essentially what we are the submitted language that was asked for by a commenter was to attempt to leverage off of existing reviewed, approved models from other regulators so that NFA wouldn't have those also in the pipeline to approve. If it's a Basel-based model, it's been approved by a Basel-type regulator or the SEC, that would be considered to be good for the purposes of starting to use those same model processes. And the qualitative and quantitative requirements that govern these models that we've imported are very consistent with those same type of reviews of other regulators. So that, I think, was the reason for that suggestion to the commission to consider. And I'll let Rafael talk about what he thinks that the model approval process for NFA would actually consist of.
Thank you, Commissioner Benham. So first I want to just mention in response to a prior question you had about the objective of the rules. Are we trying to get to the same place? And we definitely are. We're trying to get to the safety and soundness of the swap dealers, ultimately. There are the three alternative methods, and they are structured differently. So there's the banking approach, the broker-dealer FCM approach, and the tangible net worth. And they're structured differently, but whenever they use models, the models are used only to try to estimate the risk of the portfolio, overall, the market risk, and then the risk of the specific relationship with a counterparty, and that's the credit risk. And in all cases, they're using, at the moment, the same underlying model, which is the Basel-based model. That may change. It's been changing for, I think, forever. They're just always changing. There were changes after the crisis, and there's some that have not been fully adopted, but we intend to use those same models. So there's really just one style of model, which is the one that is globally followed and established by Basel. And I think there's over 90 countries that are represented in Basel, so it is really the global standard. And that's what we plan to use. One disadvantage of this is that there might be calibrations of the specific parameters that had been made by the people that participate in Basel, which are generally the central banks of countries, that might put an emphasis on more emphasis and more detail in certain parts of the business of the financial world that may not be exactly the ones that our dealers follow. So there might be need for recalibration of some parameters. Possibly we'll have to learn with experience. By the way, that's the way I think about whether 8, 6, or 4. There's no change of structure, no change of the proposal. It's a question of recalibrating some parameters. And I think that that's just appropriate. Then finally, on the advantage of having these Basel models is that we have a lot more people looking at how they perform. We can get informed by the global experience. It's very difficult to find people that can do the examinations and the approvals and the governance of these models and the examination and audit of these models. So following the global standard allows us to tap into a pool of experts and specialists that we don't need to have somebody who knows the CFTC way, but it follows that process. It's more generic. We do think it's going to be a big challenge to do the approval and the ongoing monitoring of this. We're going to be relying, like we have in the case of, for example, the uncleared margin, we're going to be relying heavily on the NFA, and we're going to have a program in how we work with the NFA to ensure that the oversight is appropriate. And it is a challenge, and we'll be looking for help from the Commission in developing that program.
Just to add briefly, sorry, Mr. Commissioner, we are indeed actively working with the National Futures Association to design that very kind of process when indeed we do get a final rule to implement.
Thank you. Two final things, and then I'm going to get through my statement. Associate myself with Commissioner Berkovitz about the comment about harmonization. I know, Director Sterling, you pointed out 4SE, and harmonization is an absolute key priority for the agency. It has been for decades, as long as we've existed. It's good from a regulatory perspective, it's good from a market participant perspective, but certainly having read the document, there's a lot of mention of harmonizing with the SEC, which has recently finalized some of its capital rules. But I caution a full-on sort of head-first approach to harmonization, given the fact that we have unique markets, different risk perspectives, and of course, as Commissioner Stump pointed out, a very diverse participant pool. The thing, I'll end off on just a note. I don't even need to make this a question and answer, but this is really the reason that I'm unfortunately not going to be able to support the rule. Yes, the core of it is opening up the comment period again from the 2016 rule, but there are a number of questions, additional questions, and I'll just point out the leverage ratio question. If I'm correct, that was not in the 2016 or the 2011 document, and also the alternative compliance mechanism, which is an SEC rule and is also not in our 2016 proposal. I understand the thrust of the document is focused on the 2016 proposal, which I think is important. I applaud both the chairman and you for working on this, but given the fact that we're adding new questions which are proposing new ideas, which would require new data and new different ways of thinking about the capital rule writ large, there's too much risk in my mind for going astray from what we are presenting to the public, which is just at its core a reopening of the comment period. So I'm going to stop there and read my statement, and then I'll finish it up, Mr. Chairman. I respectfully dissent from the CFTC's decision today to reopen the comment period and request additional comment on proposed regulations and amendments to implement Section 731 of the Wall Street Reform and Consumer Protection Act, which requires the CFTC to establish capital rules for all registered swap dealers and major swap participants that are not banks, including non-bank subs of bank holding companies, as well as associated financial record-keeping and reporting requirements. While I would have been comfortable supporting the reopening as a matter of moving this critical Dodd-Frank rule forward to finalization, to the extent it introduces supplementary avenues for future rulemaking, such as leverage ratio requirement, it is a deception. Impulsively inviting comment on matters tangential to the 2016 capital proposal, but perhaps relevant to determining appropriate capital standards and methodologies, as opposed to a thoughtful reproposal, sacrifices discipline for expediency and runs afoul of proper process for notice and comment. I will not be complicit in supporting Commission action that I believe could invite backdoor rationalization when finalization is before us. The public deserves and our integrity demands that we play by the rules. Today's action is a reopening of the comment period and a request for comment, rather than a true proposal. And thus, the 2016 capital proposal remains the only concrete indicator to the public of the Commission's intentions. If the 2016 proposal is an extreme overshoot, the appropriate way to provide the public with an opportunity to comment is to issue a reproposal. Asking further questions without a clear signal as to where the Commission is going, at the minimum risks further slowing this nearly 10-year effort to finalize a capital rule by adding an unnecessary step to the process in the form of a reproposal at some time in the future, and at worst incites the agency towards an exercise in creative reasoning outside the bounds of process. Too often over the last couple years, I believe this agency has slowed its own progress by snaking outside clear Administrative Procedure Act trajectories and adding unnecessary steps to the rulemaking process. In part, I fear that we are doing the same thing today. The competing threads throughout the reopening make it harder for the public to discern what the Commission is proposing to do, and we will make it more difficult to effectively comment on the existing proposal from 2016. This creates undue risk under the APA and arguably poisons the well in regard to the reachable goals of this new request for comment. To reiterate sentiments made in my first speech as a CFTC commissioner, capital is a cornerstone financial crisis reform that is critical to protecting our financial institutions and the financial system as a whole, specifically from systemic risk and contagion, but also from unintended consequences if capital and margin levels are applied and set without due regard to the uniqueness of our financial markets and market participants. I appreciate that in moving forward, we must heed our directive to establish capital standards appropriately and in due consideration of other activities engaged in by swap dealers and major swap participants, such that we ensure that we do not penalize commercial end users who need choices and benefit from competition in our markets. The reopening, our overarching premise is that the chosen response to certain uncertainties at the time of the Commission prior proposals resulted in recommending standards that, in application, could in no way be justified as appropriate to offset the greater risk to swap dealers and major swap participants and the financial system, such that the only solution for the potentially extreme overshoot is to dial it back. With the passage of time comes a nagging amnesia to the pain that the crisis brought on American households and the global economy. We cannot forget that undercapitalization was at the heart of the crisis. The overall changes to the derivatives market over the last several years, the Commission's adoption and implementation of margin rules for uncleared swaps, and growing knowledge and experience with swap dealers, and recent movement by the Securities and Exchange Commission in finalizing capital, margin, and segregation requirements, as well as financial reporting requirements for security-based swap dealers and major security-based swap participants, provides a reasonable basis for affording the public an opportunity to reevaluate the 2016 proposal. However, to the extent the reopening seeks additional comment on both broader issues of harmonization and more targeted proposals regarding what amount of capital is appropriate and what methodology is used, its focus on solidifying a data-driven approach should send a strong signal that the Commission must justify its final determinations with respect to capital standards. To reiterate, I would have liked to support today's Commission's action to the extent it would move us toward a final rule on a matter that is critical to the safety and resiliency of our markets, the supplemental concepts for consideration, and overarching premise that we overshot the mark badly in 2016 raises concerns. If the 16 proposal is an extreme overshoot, and if there are alternative methodologies and concepts to consider because of new market data since then, the appropriate way, in my view, is to provide the public with an opportunity to comment, is to issue a reproposal. While would I've liked to stand with my fellow commissioners today in supporting this first step towards a final capital rule, I cannot justify it under these circumstances. Again, I'd like to thank the staff for all of your hard work. I really appreciate the time you've given me and my staff, and I certainly look forward to working with you and the chairman in the future to get this rule done in an appropriate way.
Thank you very much, Commissioner Benham. Commissioner Quintens.
Thank you, Mr. Chairman. I think what I'm going to do is I'm going to read my statement on the rule first and then maybe ask some follow-up questions from it. Because with all due respect to my colleagues, I significantly disagree with a number of the characterizations of this, as well as what constitutes a recollection of what occurred. And I'd like to either set the record straight on that or at least provide my opinion. I have long said that finalizing capital requirements for FCMs and swap dealers is perhaps the most consequential rulemaking of post-crisis reforms to get right. The financial crisis exposed serious vulnerabilities in the financial system, uncollateralized, opaque bilateral exposures which, under the right circumstances, could have and ultimately did cause a panic and liquidity freeze due to concerns around that counterparty credit risk. This panic, in my opinion, transformed a significant recessionary event into the crisis as we know it. Importantly, since the financial crisis, global regulators, and certainly those in the U.S., have implemented many policy reforms like central clearing and margin for uncleared swaps, designed to bring transparency to those exposures. but I've long lamented prior regulators' implementation of important swaps market regulatory reforms by viewing them in isolation of each other, trying to calibrate each of them in a way that it alone could have prevented the crisis. In fact, I think the elegance of the reforms is that they work together and build upon each other. Therefore, in my view, it is wrong to think of capital in terms of what levels should have existed during the financial crisis that could have prevented it from occurring. Very few capital regimes, in my opinion, could have provided the market with enough certainty, given the size and nature and the opacity of those exposures, to have removed the possibility of a panic, and those regimes that could have done that would have rendered the swaps market obsolete or uneconomic. Therefore, regulatory capital regimes implemented to respond to the last crisis need to respect the increased transparency and the certainty which other reforms have already brought to the market. I believe we are asking the right questions in this reopening to respect that progress and calibrating our own capital regime appropriately. The final pillar of our Dodd-Frank Act reforms, capital ensures that firms are able to continue to operate during times of economic and financial stress by providing an adequate cushion to protect them from losses. Just as important as the safety and soundness of individual firms, capital is designed to give the marketplace as a whole confidence that any firm has a high probability of surviving the next crisis. Capital requirements also create important incentives that drive market behavior. The cost of capital may be the most determinative factor in a firm's decision to remain or become a swap dealer or to continue to provide clearing services to clients in the case of an FCM. If capital costs are too inexpensive or too inappropriately calibrated, firms will restrict certain business activities, end unprofitable business lines, or in some cases exit the swaps or futures markets altogether, which we have already seen. As a result, over time, the swaps and futures markets will become less liquid, less accessible to end users, more heavily concentrated, and less competitive. These are not the hallmarks of a healthy financial system, and in fact, I think they are all things that a lot of us on this dais have expressed concern about. Therefore, appropriate capital levels are directly linked to both the health and the vibrancy of the derivatives markets and to the sustainability of the entire financial system more broadly. To promote a vibrant derivatives market, I believe it is critically important that the CFTC finalize a capital rule that is appropriately calibrated to the true risks posed by a swap dealer or an FCM's business. So I'm pleased to support the reopening and the request for comment before us today. This document solicits comment on key issues that the Commission must get right in the final rule to ensure that capital requirements are appropriate and commensurate to a firm's risk. I appreciate that market participants have commented on 2 prior capital proposals already, and the Commission will continue to consider all past comments in moving forward with any final rule. Nevertheless, I hope commenters use this opportunity to provide the Commission with much-needed data and quantitative analysis demonstrating the impact that various choices contemplated would have on a firm's minimum capital level, and by extension on that firm's ability to participate in the market and adequately service its clients. Data is going to be vital and should always be vital to the Commission's ability to evaluate various capital alternatives and identify those alternatives that would render certain business lines uneconomic. Let me talk just briefly about the 8% risk margin amount. We heard from many commenters that of all the alternatives, the 8% risk margin amount would act not as a capital floor as intended, but rather be the primary driver of a firm's capital allocation and as a potential binding constraint across their business. And whereas FCMs are currently required to include in their minimum capital requirement 8% of the margin required for their futures and cleared swaps customer positions, the 2016 proposal expanded the 8% risk margin amount to include proprietary futures, swaps, and security-based swaps positions for FCMs and swap dealers electing the net liquid asset approach. In addition to these proprietary positions being included in the risk margin amount, these FCMs and SDs would also be subject to capital charges on these proprietary positions. I hope commenters can provide us with data showing the capital costs of including proprietary positions for the first time in an FCM's risk margin amount. To the extent possible, it would also be helpful to see how different risk margin percentages or a different scope of products included in the margin amount impacts the minimum capital requirements for an actual or hypothetical portfolio of positions. I have more that I will release in my full statement, but let me stop there and maybe just ask a couple of quick questions. Director Sterling, do you agree that it is important to have data to finalize this rule?
Wholeheartedly, Mr. Commissioner.
Do you feel as though we have that data currently?
No.
In the, and let me speak to Tom for a second. I feel like we've been having a capital conversation for about 10 straight months now, and I appreciate all of the hard work that you have put into helping our office understand the different regimes that are out there, as well as work with the SEC to make sure that the impact of various choices was well understood. And I think we can take a small amount of credit for what I think turned out to be a very good proposal from the SEC's perspective in terms of how it impacted a very broad part of our marketplace. But maybe, Tom, I can ask you a kind of a direct question that in the 2016 proposal, we did suggest 8%. Was that number heavily data-driven, or was it referenced through some other concept?
It was not heavily data-driven. It was based on the existing, as you just mentioned, the existing FCM sort of requirement of 8% of the customer transactions, and it was incorporated into this approach. That's correct.
Okay. And I would like to point out that it's easy to kind of focus and ridicule or badmouth certain percentages that may seem large or small, but I think the fact of the matter is we all understand math, and we have to realize that that is a percentage of a base, and that percentage may be large or small dependent on the equation of what it multiplies. And in the scenario of the 2016 proposal, the base seems to be very large. It grosses up all counterparty net margin amounts across proprietary positions as well as swaps and security-based swaps. Is that correct?
That's correct.
And there's also been a lot of conversation around harmonization issues. I'd like to point out that if we were harmonizing for harmonization's sake, then the only base that we would include would be security-based swaps. Is that correct?
That's correct.
Okay, so maybe we should set that record straight, and we can talk about whether or not we should harmonize for harmonization's sake in that context. I'd also like to note that the proposal asks questions about a number of different percentages or any percentage that seems to be appropriate to the safety and soundness of the firm and the economic benefit that they should derive from dealing in these products. It also asks about eliminating this concept specifically, and I don't believe, and I know, it's not because we don't think there should be any minimum capital requirements, but it's because we're asking whether or not it may be a very difficult thing to actually calibrate appropriately to the different businesses and the different portfolios and the books that they have, that it may be better, which we'll ask about, to rely on the minimum capital standards that are already in place through other approaches. Is that correct?
That is correct. I think that we do ask about that, and it's in the context, Mr. Commissioner, if I may, of sort of recognizing that a certain portion of capital is consensual in the sense that a firm knows best its risk exposures. We have to provide a framework of choice for them, and they have to design something consistent with standards that works for them and works for us. So it will be difficult and data-driven, and that's why, among other reasons, we asked that question.
Okay, thank you. And just maybe two final points. One is thank you for a long comment period. I think 75 days is a really robust amount of time to get the data that I think is necessary to ensure that we appropriately calibrate this regime. And I would also like to note, I applaud your inclusion of questions around the tangible net worth approach and how or if we can recognize various forms of collateral that end users have better access to than maybe the cash collateral that is normally thought of in the bank regulators' recent final rule on SACR. They eliminated the alpha surcharge on positions in recognition with commercial end user firms in recognition of the benefits that some of that collateral can provide. And I'm interested to hear commenters' perspectives of that, and I applaud you for including that question. Thank you all very much for your hard and diligent work and your communication with my office. Thank you, Mr. Chairman.
Thank you very much, Commissioner Quintens. I'm also pleased to support the reopening. So let me just make sure I totally get this straight, because I'm the new guy here. We have no capital requirement right now for swap dealers on the books here. Is that right?
Yes, sir.
Okay, so it's been a 9-year rulemaking period. All right.
Yes.
And then on the point, at a later time, I think I'll say something about capital, because this is an area that I actually happened to write a doctoral dissertation on the Basel capital requirements for banks, but I'm not gonna, our job is to help educate the public, not punish you, so I will not say anything more about that. But there are different capital requirements for different objectives, right? So the capital requirements, this goes to a good question Commissioner Benham had about, is it, what's the end goal? I do think there are different strategies. The Basel capital requirements, in my view, should generally be more conservative because they're dealing with insured depository institutions that have access to the discount window. I think when we look at broker-dealers, swap dealers, and particularly FCMs, the goal has always been focused on customer funds and making sure that not to prevent insolvency, but rather to ensure there's enough capital to make sure customers are made whole in the event of a solvency. So we'll have to sort of think about those various strains, but I think you see that in our FCM regime. We've had a capital requirement there for decades. On the issue about the leverage ratio, I just want to make sure I'm reading the question right. My understanding is that in no way does this contemplate that if we went to final, there would be a leverage ratio. Is that right?
That is correct, Mr. Chairman.
So it's just a question about down the line, the 8% or the margin-based capital requirement that Commissioner Quintens was speaking about. The question is, down the line at a future rulemaking, is that something the Commission should consider in lieu of the margin-based requirement?
Yes, sir, that's right.
All right. Okay, well, I think I will ask whether the commissioners are prepared to vote. Okay. Mr. Kirkpatrick, would you please call the roll?
Thank you, Mr. Chairman. The motion now before the Commission is on the approval of the proposal reopening the comment period and requesting additional comment with respect to capital requirements for swap dealers and major swap participants. Commissioner Berkovitz.
No.
Commissioner Berkovitz votes no. Commissioner Stump.
Aye.
Commissioner Stump votes aye. Commissioner Benham.
No.
Commissioner Benham votes no. Commissioner Quintens.
Aye.
Commissioner Quintens votes aye. Chairman Tarbert.
Aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 3, the noes have 2.
Thank you very much. The ayes have it, and the motion to reopen the comment period carries. This time, I'd now like to invite our third and final presentation. In this case, it's on the proposed rule that would amend the swap clearing requirement exemption for inter-affiliate swaps. Specifically, from our Division of Clearing and Risk, we have Director Clark Hutchinson, Special Counsel Melissa Darcy, and Deputy Director Sarah Josephine. So Clark, Melissa, and Sarah, the floor is yours.
Thank you. Good morning, Mr. Chairman, Commissioners, fellow staff. This is my first appearance at an open meeting of the Commission, and I'd like to take this opportunity to briefly introduce myself. My name is Clark Hutchison, and I am the Director of the Division of Clearing and Risk. Prior to joining the Commission in July, I spent over 3 decades working for a number of large financial institutions in the area of clearing and risk management. This morning, my staff and I will be presenting a proposal to amend the Commission Regulation 50.52, the inter-affiliate exemption from the Commission's swap clearing requirement. When the Commission adopted the inter-affiliate exemption, it established conditions that affiliated entities must satisfy when electing the inter-affiliate exemption in relation to cross-border swap activity. Of those conditions, the alternative compliance provisions were time-limited and expired in 2014. Since that date, DCR staff provided targeted relief to allow eligible affiliates to continue using the expired compliance frameworks. Today's proposed amendments would reinstate the alternative compliance provisions with minor modifications to align with the staff no action relief that is currently in place. I would like to recognize this morning Sarah Josephson, a Deputy Director, and Melissa Darcy, a Special Counsel from DCR, for their hard work on this rulemaking proposal. In addition, I would like to thank our colleagues in the Office of the General Counsel, Carlene Kim, Paul Schlichting, and Mark Pfeiffer, and our colleagues in the Office of the Chief Economist, Scott Mixon, and Steve Kane for their time, effort, and helpful assistance in preparing this rulemaking. Thank you all. I'll now ask Melissa to introduce the proposal the Commission will be considering this morning.
Good morning, Mr. Chairman and Commissioners. I would like to thank you for this opportunity to present the rule proposal this morning. The proposed amendments would update Commission Regulation 5052 to reflect current market practices with respect to a specific condition of the inter-affiliate exemption from the swap clearing requirement. The proposed edits accomplish 3 things. First, the proposal would eliminate the expiration date of March 11, 2014, and reinstate the alternative compliance provisions. Second, the proposal would expand the number of jurisdictions in which affiliated entities could be located and not be constrained by a limit on the aggregate notional value of swaps eligible for the exemption. And third, the proposal would streamline the provisions under Commission Regulation 50.52 to delete any unnecessary or unused provisions. The proposal seeks comments from the public regarding all of these changes, particularly if any market participants rely on a provision that would be deleted. We would request that people inform us of that. Overall, this proposal is intended to reflect the Commission's dedication to promoting sound regulation and improving clarity in its rules. Before discussing the specifics of the outward-facing swaps condition that is the subject of this proposal, I would like to briefly outline the general structure of the Commission's inter-affiliate exemption from the swap clearing requirement. In 2013, soon after the Commission issued its first clearing requirement for certain interest rate swaps and credit default swaps, the Commission adopted an inter-affiliate exemption as well. Under Section 4C, Public Interest Exemption Authority in the Commodity Exchange Act, the Commission is permitted to exempt certain transactions or persons entering into transactions from requirements or provisions of the Act in order to promote responsible economic or financial innovation and fair competition. The Commission determined that inter-affiliate transactions provide an important risk management role within corporate groups and that such swaps, if properly risk managed, may be beneficial to the entity as a whole. The Commission recognized these benefits and adopted the exemption for eligible affiliated entities subject to certain conditions. For example, these conditions include the requirement to maintain a centralized risk management program and to report certain information to a swap data repository. There is one more tailored condition to the inter-affiliate exemption, the outward-facing swaps condition, that is focused today. The outward-facing swaps condition was adopted in order to address the potential risk that eligible affiliated entities would evade the Commission's clearing requirement through third-party trades with foreign affiliates that are not subject to a domestic clearing regime that covers analogous counterparties or products. As part of its rationale for adding an outward-facing swaps condition, the Commission explained that it would not prejudge the potential incentives or ways of evading or complying with the Commission's clearing requirement and the inter-affiliate exemption from clearing. The Commission viewed the requirements under Commission Regulation 50.52 B4 as a transparent way to mitigate the risk that affiliates would use the inter-affiliate exemption to evade the clearing requirement. Now that the Commission has had some experience monitoring the election of the inter-affiliate exemption, and we have heard feedback from market participants using the exemption, we feel it is an appropriate time to reconsider the conditions. The Commission established 5 mechanisms through which counterparties could comply with the outward-facing swaps condition. 1, counterparties could elect to clear the swaps through a registered or exempt DCO. 2, counterparties could comply with the requirements of a non-U.S. clearing regime that the Commission has determined to be comparable and comprehensive, but not necessarily identical to the Commission's clearing regime. 3, counterparties could comply with an exception or exemption from the clearing requirement. 4, counterparties could comply with an exception or exemption under a foreign jurisdiction's clearing requirement. Or 5, counterparties could clear the swap through a clearing organization that is not registered with the Commission as a DCO, but is subject to supervision and has been assessed to be in compliance with the principles for financial market infrastructures. Based on concerns that non-U.S. clearing regimes might not be implemented quickly enough to permit market participants to use some of these outward-facing compliance mechanisms, the Commission adopted a set of time-limited alternative compliance frameworks. A number of the outward-facing swap provisions would require the Commission to issue comparability determinations with respect to the clearing requirement. To provide additional flexibility in the absence of this determination, the Commission adopted the alternative compliance frameworks. The alternative compliance frameworks to the outward-facing swaps condition generally permit counterparties to enter into affiliated swaps without clearing the outward-facing swap, so long as variation margin requirements are satisfied. When the Commission adopted the alternative compliance frameworks in 2013, it believed the clearing requirement regimes were under development in a number of other non-U.S. jurisdictions. The Commission intended for the alternative compliance frameworks to assist market participants transition to broadly similar clearing requirements around the globe. In the absence of broadly similar non-U.S. clearing requirements, eligible affiliates could enter into uncleared swaps with an unaffiliated counterparty outside of the U.S. and then enter into uncleared swaps on a back-to-back basis using the inter-affiliate exemption that could transfer risk back into the United States. The approach to adopting and implementing clearing requirements around the globe was less coordinated. Some jurisdictions took longer than expected to implement their own clearing regimes. In response to requests from counterparties concerned about complying with the outward-facing swaps condition, DCR staff issued a no-action letter to permit counterparties to continue using the alternative compliance frameworks. DCR subsequently extended its no-action relief in 5 additional letters. The most recent letter, dated December 14, 2017, provides relief to eligible affiliates that comply with the alternative compliance frameworks as described in the letter until the earlier of December 31, 2020, or the effective date of any amendments to Commission Regulation 5052. Eliminating the expiration date in Commission Regulation 5052 would reinstate the alternative compliance frameworks and allow eligible affiliates to continue using these frameworks with the additional certainty of Commission regulation rather than relying on DCR staff to continue issuing no action relief. The second proposed edits to Commission Regulation 5052 would expand the list of jurisdictions in which an eligible affiliate may be located and still take advantage of an alternative compliance framework without subjecting the swap to a 5% test limit. The Commission originally adopted the alternative compliance frameworks with no limits on the number or percentage of inter-affiliate swaps that could be entered into with an eligible affiliate counterparty for those located in the European Union, Japan, or Singapore only, so long as the variation margin requirements were satisfied. After the Commission expanded its interest rate swap clearing requirement in 2016, DCR anticipated that eligible affiliates would enter into more swaps in jurisdictions within which the official domestic currency was subject to the Commission's clearing requirement. For example, the Commission expanded its fixed-to-floating interest rate swap clearing requirement to include the Mexican peso, and we anticipated that eligible affiliates would conduct additional swaps with entities in Mexico. As a result, DCR issued no action relief to eligible affiliates if one of the counterparties is located in an expanded list of jurisdictions to include 5 additional countries. Australia, Canada, Hong Kong, Mexico, Switzerland, and the United Kingdom. The DCR relief, in line with Commission Regulation 5052B4, limits the amount of uncleared inter-affiliate swaps that an eligible affiliate counterparty located in the U.S. may enter into with affiliate counterparties in jurisdictions other than Australia, Canada, the European Union, Hong Kong, Japan, Mexico, Singapore, Switzerland, the United Kingdom, or the United States. An eligible affiliate located in the U.S. may not enter into swaps that are valued at more than 5% of the aggregate notional value of all of its swaps, which are subject to the Commission's clearing requirement, with an affiliate located in a jurisdiction other than those countries. This limitation is intended to prevent concentrations of uncleared inter-affiliate swaps from building up in jurisdictions that do not have established clearing regimes. In both alternative compliance frameworks, the proposal is modifying the set of jurisdictions that are subject to the 5% notional amount limit to include fewer jurisdictions, and is increasing the set of jurisdictions in which eligible affiliate swaps are not limited. In addition, this proposal makes one change that is different from the current no-action relief provided by DCR. The proposal expands the list of jurisdictions to add the United Kingdom as a separate jurisdiction from the European Union in the event of Brexit. Third, the proposed edits to Commission Regulation 5052 would streamline the provisions and alternatives offered so that any unnecessary or unused provisions offering relief would be deleted. The proposal does not include a separate set of compliance instructions for eligible affiliate counterparties if one of the affiliates is a non-financial entity and neither of the affiliates is affiliated with a swap dealer or major swap participant. This alternative would be deleted because we do not believe that non-financial entities that are not affiliated with swap dealers are electing the inter-affiliate exemption currently. The proposal invites commenters to discuss whether or not the deletion is appropriate. The proposal also deletes the option given to eligible affiliates to pay and collect full variation margin daily on all swaps entered into between the eligible affiliate counterparty and unaffiliated counterparties. Staff believes that all eligible affiliates choose to pay and collect variation margin with their own affiliates now, and there's no reason to preserve the option to pay and collect variation margin with the unaffiliated counterparties if that is not being used. The revisions also propose to include a new definition for the term United States in order to clarify which eligible affiliates will qualify for the alternative compliance frameworks. Overall, the proposed changes to Commission Regulation 5052 reflect an effort to reevaluate and update the outward-facing swaps condition. Staff has been monitoring the swaps transaction level data to gain additional information about the types of entities that are electing the inter-affiliate exemption, and more specifically, the eligible affiliates that are electing the inter-affiliate exemption and complying with the outward-facing swaps condition through one of the alternative compliance frameworks. Staff has identified roughly 60 financial entities that are located outside of the U.S., and it believes to be complying with the outward-facing swaps condition using the alternative compliance frameworks. Based on reviews of swap data repository information, these types of entities electing the inter-affiliate exemption are almost exclusively financial and affiliated with a registered swap dealer. While we note that the entities electing the exemption may change over time based on entity structures and business needs, the number of entities electing it and the locations of the entities around the globe have remained relatively stable over the past few years. There also appears to be an increase in the number of entities electing the inter-affiliate exemption from jurisdictions that were added through no-action relief in 2016 and 2017, such as Australia, Canada, and Mexico. This slight shift is consistent with the expectation that additional entities would elect the inter-affiliate exemption as it became available in additional jurisdictions without a 5% test limitation. Again, the proposed changes are intended to codify the current no-action relief, which provides that eligible affiliates may continue to use the alternative compliance frameworks as modified to comply with the outward-facing swaps condition. The goal of this rulemaking is to clarify and streamline the conditions required for eligible affiliates. We hope this information is helpful and would be glad to answer any questions this morning.
Thank you very much for that great and very detailed presentation, particularly to you, Melissa. At this point, I'll entertain a motion to approve the division's proposed rulemaking relating to the clearing exemption.
So moved.
Second.
Thank you. I'd now like to open the floor for commissioners to ask any questions or make any comments. I don't have any questions. All that I'll say is you know, I'd like to see these instances where we have a codification of no action letters, in this case, a temporary no action letter. You know, once we figure out, you know, what the right answer is, to codify it, I think is very important. So it's not only good policy, it's also good government. Commissioner Quintens?
Thank you, Mr. Chairman. Just a couple of quick questions. Thank you for the presentation, Melissa. And I think you covered this, but I just wanted to be a little more clear. Or what are the types of entities that typically elect this exemption? Are they unregistered commercial firms, or are they more registered firms in our space?
Yes, they tend to be financial entities that are generally registered with the Commission or affiliates of registrants, and we've seen them be fairly consistent over the years.
Okay. And I wanted to ask, again, you brought this up a number of times, but I just wanted to raise it and see if I understand it. The rationale for preserving the 5% limitation on affiliates variation margining their swaps when that affiliate is located outside of one of the 9 jurisdictions that hasn't adopted swap clearing requirements. Can you just tell me that explanation again in terms of where you think risk can come into the system versus the protections that we have in place right now for those entities and these affiliates from a variation margining perspective?
Sure. So we think it's important to preserve the 5% limit because not all jurisdictions have adopted a robust clearing regime, and not all have an uncleared margin requirement. So for those jurisdictions where somebody is entering into an uncleared swap, the risk is that they could pool concentrations of risk in those jurisdictions that have less domestic oversight and are subject to fewer requirements on that side. And then there's always the risk of the back-to-back transfers back to the U.S., and that's why we have the variation margin requirements to kind of prevent that.
Okay, thank you. And the final question, which I know the answer to, maybe I'll just say it, that I'm correct that this exemption from the clearing requirement doesn't provide relief from the trade execution requirement. Is that correct?
That's correct. That's being considered separately.
Okay. I would like to preemptively express my support for considering that. So thank you very much for your hard work.
Thank you. Commissioner Benham?
Thanks, Mr. Chairman. Thank you, Melissa and Sarah, for your work. Thanks for taking your time to talk with me and my staff a few days ago. I do have a statement which I'll post on the CFTC website, but just I'll highlight some questions and some of the themes in my statement within the questions. In the 13 preamble and then also in this draft, there is a statement which I think is worth discussing because it's a little bit counterintuitive, but I do believe, and Melissa, you pointed it out, why we're moving forward and the rationale despite the statement. But the statement, by and large, recognizes the fact that paying and collecting variation margin does not mitigate counterparty credit risk to the same extent that central clearing does. So we're sort of taking a step in a direction where we recognize it's not as a safe and resilient sort of mitigant against risk, VM versus central clearing. Can you just talk a little bit about the rationale that we're moving forward? And I know it's been embedded in the statement you made, Melissa, but I think it's important since we are recognizing the fact that this is not the most robust risk mitigant, yet we're going forward with it, I think would be helpful.
Sure. I think that the Commission made efforts to recognize that clearing is the best protection in this instance, and yet it's not necessarily workable for these affiliated entities that are going to be operating outside of the U.S. in jurisdictions that have not reached that level of regulation that the CFTC has, for example. We don't necessarily want to put affiliated entities at a market disadvantage to impose requirements on them when we do feel that the variation margin protects against any of that outside risk coming back into the United States. Not only does it force the counterparties to market, it also creates an inhibition to taking outsized risk.
Thank you. Dovetailing off of that, which is, I think, and we discussed this a little bit, this is why I feel comfortable supporting this proposal. Despite VM not necessarily being the best risk mitigant, and I'm sort of making that term up here, but we do have a number of sort of powers within the CFTC, within 5052, to identify those who are electing this exemption, and then beyond that, having some lens into the scope and the size of the individuals and the depth of the market. Can you talk a little bit about that? I know, Melissa, you pointed it out, but also some of the special call and anti-fraud and anti-evasion authorities that we retain. Just for me personally, as a measure of getting comfortable with what we're doing, what we're proposing, despite VM not being the best methodology, we do as an agency, both from a surveillance standpoint and ultimately, if needed, from an enforcement standpoint, the ability to identify the risk, see where the pockets of risk might be forming, and then do whatever due diligence and action we need to resolve that.
Sure. I think it's important to note that in both the initial adopting release, the Commission noted that it was very intent on preventing evasion of the clearing requirement when it adopted this exemption. And we try to make that point today as well. So one of the ways that we can do that is by, as you said, monitoring the entities that are electing it, monitoring how they're electing it, and making sure that, for example, they're complying with the alternative compliance frameworks, that the notional value of their swaps complies with the 5% test, if that's applicable. And then we also have separate anti-evasion authority under 50.10 that exists and we use to monitor and prevent evasion of the clearing requirement.
Thanks. Lastly, and talking about methodology a little bit earlier with the DSIO team, do we have any lens into the methodologies that the entities will use in calculating VM?
So that is not something that we have prescribed in the rules. So they are free to select and choose their own variation margin regimes internally between the counterparties, and we do not necessarily have a lot of insight into how they are doing that.
Okay, thank you. Again, thanks for your work on this and your time with me. And I think with respect to some of these questions, I look forward to the comments from the public so that we can move forward with this. Like you said, Mr. Chairman, I think it's an efficient and a timely and necessary thing to finalize these legacy no-action letters that have been around for a number of years. Thank you.
Thank you, Commissioner Stump.
I don't have any questions specifically, but I would like to say that I think this is exactly what the no-action relief regime is designed to achieve. Oftentimes, regulators around the world go to finalization of rules at different paces. We obviously were first movers in many regards, and so it created an unbalanced quagmire, frankly, for a lot of affiliated entities who could not make sense of what their business model would allow them to do given our mandates. And so I think this was designed to encourage them to continue to operate in this space in a way that made sense. And I am very happy we are finalizing this in the form of a rule. I also, when we talk about these things, just because I have some experience on the clearing side, I'm always struck by, these are things, when you think about clearing in its most fundamental sense, it's designed to eliminate counterparty credit risk. And so I'm going to oversimplify what I think we're doing here. The counterparties at the base of this proposal are in fact affiliated. So to the extent we've built in protections to ensure that risk is not brought back to the United States in a way that is harmful to our system, that's great. But clearing is more about counterparty credit risk than it is about the system itself. Certainly it can help with that, but I think this is something that we should all be reminded of. So thank you all so much for your efforts, and thank you for the great presentation, Melissa. And Clark, welcome to the CFTC.
Thank you very much, Commissioner Berkovitz.
Thank you, Mr. Chairman. You may be relieved that Commissioner Stump just made a number of the remarks that I was going to make, so that can cut some of my time off. But I totally agree that under the circumstances, the expiration of the time frame in the original regulation of 2014 for the Europeans to get their clearing requirement, or the 3 jurisdictions, necessitated the continuance of these provisions necessary by no action relief. Now, at that point, the commission could have gone through a notice and comment rulemaking or whatever as an alternative, but relief needed to happen, conditions were changing, and the no action relief enabled the status quo to basically continue and the commission to adjust the program to as these changing global market conditions. And then the other jurisdictions, as they were coming online, it enabled the program, the non-U.S. affiliates to continue operating in those jurisdictions without a competitive disadvantage, at the same time exchanging variation margin to protect the risk from coming back into the U.S. It was necessary at the time. We have experience with that, and we have the swap data. You've cited the swap data statistics. Given that experience and now our comfort level, also I think it was extremely informative that we were able to determine which of the alternatives people were using and not using and who was using it, and therefore base a final regulation on an actual utility to the marketplace and informs that final regulation. So I think the no action relief was appropriate at the time, and now it's totally appropriate and the right thing to do to codify it so people can see it in the regulation. I just have a couple questions. Why was there an expiration date? What was the thinking, if you're aware of initially? And I confess I was here at the time, but I don't remember that specific of the expiration in the initial regulation of 2014. What was that purpose of that?
The idea at the time was that that would be when the foreign jurisdictions would have their regimes in place, that it would move that quickly.
So, and the fact is that reading the release, that there's no foreign jurisdiction that has a comparable clearing requirement, and we don't really expect that to be the case?
That's correct. There's no other jurisdiction that is as consistent with the CFTCs in terms of the scope of products that are required to be cleared and the types of market participants that are required to clear.
But these non-U.S. affiliates in these foreign jurisdictions are still subject to the non-comparable clearing requirement of the foreign jurisdiction. Is that correct?
Yes.
And there is some overlap. Presumably, they may not be comparable and comprehensive. We may not be able to make a comparability determination, but there's going to be significant overlap between those two clearing requirements?
There is. I mean, the one that is the closest to the U.S. is the European Union's clearing requirement. It gets, in terms of the product scope, fairly close to where we are.
So if there's a delta between a certain class that we require to be cleared and they don't require to be cleared, there's still the variation margin. This alternative compliance framework requires the variation margin between the non-U.S. affiliate and the U.S. affiliate, correct?
Yes.
But would it be correct still, though, to take advantage of these alternative compliance frameworks, they have to do variation margin on all their swaps subject to the U.S. clearing requirement?
It's all of their swaps with the other eligible affiliates.
Even if that eligible affiliate is then subject to a clearing requirement in that eligible affiliate's home jurisdiction?
If they choose to clear the outward-facing swap, that's one way to comply with it. So if they are subject to the non-U.S. foreign clearing requirement and then they comply with it, then they've already satisfied the outward-facing swaps.
Okay.
Outward-facing
swap. This does not relieve the non-U.S. affiliate from complying with its home jurisdiction's clearing requirement, does it?
No.
Okay, so in many instances, that non-U.S. affiliate will still be required to clear their outward-facing swap.
That may be true.
It's just the delta where the delta between the foreign jurisdiction's clearing requirement and our clearing requirement that's going to be still subject to variation margin between affiliates.
In a sense, we're trying to protect our clearing requirement. Exactly.
Exactly. Okay. And now we have 9 jurisdictions that have a clearing requirement. So today, the set of these transactions where there's variation margin rather than where the non-U.S. affiliate exchanges variation margin rather than clears the outward-facing swap has diminished as time has gone by, as these jurisdictions have established clearing requirements.
We would expect that to be true. We don't necessarily track whether or not they're clearing under a non-US clearing regime.
Okay, so I think that's a significant point too, that there has been substantial clearing by these non-U.S. affiliates during this time. I am interested in any comments by commenters, whether, you know, there's any, what this delta still is, whether there's residual risk being imported, and I'll look forward to those comments. But I think this is an example of how regulation progresses in an ever-changing global environment. We establish a regulation, we balance, we have to protect our markets, but at the same time, we have to enable our market participants to participate in these global markets, ensuring that no undue risk is imported back into the U.S. and recognizing that competitiveness. And as jurisdictions come online and as the global financial regulatory framework changes, we can adjust. And I think this is a good proposal and reflects that sensible adjustment. So thank you. And thank you for your there's a lot of chains of transactions and conditions in this thing, and it's somewhat complicated to get your head around. But actually, when you do it, it sort of makes sense. It makes sense. So thank you, and thank you for that explanation.
Thank you. Yeah, and the key for me here is just that we are talking about inter-affiliate transactions. So these are related companies, and there's that added incentive, you know, not to let one another fail, to pay back your brother or your sister company. I think we still have that variation margin requirement in there, just in case, you know, the risk were to come back to the United States. But I think that's a different scenario than just a sort of arm's length transaction with some third party saying, no, in that case, you need to go to the clearinghouse because there is credit risk there that's of a different kind. So with that, if there are no other questions, are the commissioners prepared to vote? Okay. Mr. Kirkpatrick, would you please call the roll?
Thank you, Mr. Chairman. The motion now before the Commission is on the approval of the proposed rule regarding amendments to the swap clearing requirement exemption for inter-affiliate swaps. Commissioner Berkovitz.
Aye.
Commissioner Berkovitz votes aye. Commissioner Stump.
Aye.
Commissioner Stump votes aye. Commissioner Benham.
Aye.
Commissioner Benham votes aye. Commissioner Quintens.
Aye.
Commissioner Quintens votes aye. Chairman Tarbert.
Aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 5, the noes have 0.
Thank you very much. The ayes have it, and the motion to approve the proposed rules carries. Thank you very much to DCR for your participation, Sarah, Melissa, and Clark. Before we move to closing statements, if there are any, is there any other commission business? And we're going to be having another open meeting next week, so we will have more commission business, but not today. I'd like to go ahead now and give my fellow commissioners an opportunity to make any closing statements you might have. We'll start with Commissioner Berkovitz.
Thank you, Mr. Chairman. I don't have any further comments. I will note on the upcoming agenda, there are a number of extremely complex matters that we'll be dealing with: bankruptcy, position limits, cross-border issues. I can tell you that I'm committed. I know you've established an ambitious agenda. I can tell you I'm committed to working diligently, and my staff is committed to working diligently. But these are incredibly complex matters, and I want to make sure the Commission has adequate time to thoroughly consider. We issue good regulations when we have well-considered regulations, so we should just keep that in mind. Thank you.
And just to be clear, out of the things you mentioned, I think one will be next week, one will be in January, and one will be in February. So otherwise, I would be leaving coal in your stockings this holiday season, but I think only the cross-border rule will, among those very complex rules, will be next week. Thank you. Commissioner Stump.
I just want to again thank everyone. I know your time, the demands on your time, given what Commissioner Berkovich just laid out, are enormous, and we all appreciate all of your efforts. I appreciate all the efforts from all the people who are back here because they've spent evenings and weekends working on things of late, and I think we're all very well served to have such a wonderful staff. Just wanted to harken back to what I said in my opening statement relative to this commission's mission is the same as the commission. Our mission is the same, but our objective is somewhat different in that previous commissions were tasked with putting together an enormous new market structure for these markets, and our objective is somewhat different in that we have the benefit of the information that we have today, and it sometimes helps inform a better path forward. For example, I think that the capital proposal that has been, or the reopening of the comment period is well timed because much has changed since 2011 and 2016, and we could all be well served by a more contemporary snapshot of the issues, and especially in light of the other rules we've put in place and the rules that other fellow regulators have put in place. And the same can be said for the codification of no action relief. We have the benefit of other jurisdictions having implemented some of the reforms and us being able to have a more holistic view of things. Relative to transparency, I wanted to say just one quick thing. The Commodity Exchange Act says that whenever the commission issues for official publication any opinion, release, rule, order, interpretation, or other determination in a matter, the commission shall provide that any dissenting, concurring, or separate opinion by any commissioner on the matter be published in full along with the commission's opinion, release, rule, order, or interpretation. For good or bad, the Seventh Circuit recently reaffirmed that that is in fact our right as individual commissioners. I anticipate that several will be exercising that right after today's meeting to maybe publish dissenting views. And so I just wanted to say I think this is very important, and I wanted to suggest that I am not in any way, shape, or form opposed to individual commissioners being able to issue their dissenting or concurring viewpoints. So thank you, Mr. Chairman.
Thank you very much. Commissioner Benham.
Thanks, Mr. Chairman. I appreciate you having this meeting today. Special thanks to DSIO and DCR for your work and working with my staff, as I mentioned earlier. Also, thanks to the General Counsel and the Chief Economist for all your work with these teams. And a special thanks, I'd like to reiterate what Commissioner Stump said to my staff. It's a busy time of year at home with holiday parties and getting ready for the holidays and the new year. So the ambitious agenda has put us all on overtime, and I want to thank them for their work because it's been a long couple of weeks, and we're looking forward to next week as well. Thanks.
Thank you. Commissioner Quintens.
Thank you, Mr. Chairman. Yes, I'd like to just reiterate my sincere thanks to the staff out here for all of your hard work on the reopenings, proposals, final rules today. All the staff back here for their continued efforts and communication amongst our offices. I'm very pleased that we took some important steps today to finalizing some of the requirements of Dodd-Frank and the important reforms of the swaps market to make sure that we accomplish those in a thoughtful, rational, and data-driven way so that we can ensure that they are appropriate to the risks that we seek to mitigate. So I'm looking forward to some of the next open meetings to do the same. Thank you, Mr. Chairman.
Thank you very much. And let me also echo my appreciation for the staff for the tremendous amount of hard work I've seen in my only few months on the job, as well as the staff for the commissioners. I also commend, the idea of putting out concurring, dissenting, and other statements. I think that's really important. And I think, the public sees that, but what the public doesn't see is the often interaction one-on-one between the commissioners, between our staffs, and the agency staff as a whole to sort of make these rules what they need to be. And if you'll notice today, we had 3 measures. 2 of them were unanimous, and they were unanimous because there was a lot of back and forth between the offices to improve them. And I think someone said it earlier, I forget which commissioner, that by virtue of us being 5 individuals with some very diverse backgrounds coming at this, I think I'm a better commissioner as a result of having my 4 colleagues, and they have helped me, I think, try to focus the agenda, try to make our rules and regulations and the other things that we promote better. So that interaction is critically important, and it's particularly during this time in Washington, having a commission that not only has divergent views in some cases, but has the collegiality that we do, I think is very commendable, and I'm committed to keeping that. So with that, there being no further business, I'd entertain a motion to adjourn the meeting.
So moved.
Those in favor of adjourning the meeting will say aye. Aye. Those opposed? The ayes have it. And again, thanks so much for everyone being here today. The meeting is hereby adjourned.